Elizabeth a series of dots, she'll join them together. If you show me a series of dots, I'll look at the first one and I'll say, what does this mean? So basically tonight, we're going to be talking about some legislation, and I think that I don't get past the minutiae in little sections of this act, whereas I think that Elizabeth sees the big picture. If you like, I see the trees, she sees the forest, but we both see old growth. So I'm going to start by begging your indulgence. I want to talk about more than Bill C-51. I want to talk about another bill that is going through Parliament at the moment, called Bill C-44. And I can easily explain why I want to talk about them both as a package. The day before Bill C-51 came in the front door of Parliament, Bill C-44 went out the back door of the House of Commons into the Senate. Bill C-51 is called, what is it, the Anti-Terrorism Act of 2015. The Bill C-44 is called the Protection of Canada Against Terrorism Act. I think they're the same package. I think they go together as the same thing, and we should treat them together. What does Bill C-44 do, the one that's now in the Senate? I take it that you voted against it.
Yeah.
Oh, thank God. You never tell these Green Party.
Yeah. No, the entire caucus voted against it.
Okay, so what does Bill C-44 say? It says three things. The first thing that it says is that sources that are used by CSIS now have an absolute privilege that their identity will never be disclosed. That's very, very, very clear on that. The second thing that it does is it takes the citizenship legislation that was enacted in June and it brings it immediately into force. And the citizenship legislation that was enacted in June allows for the first time revocation of citizenship for criminal acts and anti-terrorism acts. The third thing that it does is it gives judges the ability to issue warrants to allow CSIS to operate outside of Canada. So those are the three things that aren't part of Bill C-51. Now, we are being led to believe that C-51 is a package that is designed to deal with measures that we have, recent measures that we have become very, very familiar with because the media is giving them a great deal of prominence. So let me just give you a couple of things that the government is saying Bill C-51 is about. And guess what? I have it here. I was just telling Terry, I actually have not read the whole thing. I just can't. It's impossible to do this. With my little detailed brain, I get stuck. And so I look at the bits that I know I'll understand. But if you go to the beginning of this bill, you will see something that sounds familiar. The second part tells us that it enacts the Secure Air Travel Act. Secure Air Travel Act in order to provide a new legislative framework for identifying and responding to persons who may engage in an act that poses a threat to transportation security or who may travel by air for the purpose of committing a terrorism offense. Who are we thinking about here? Government leads us into this trap of saying this is an act that's dealing with all these kids who are going across overseas to fight for IS. That's what the act is about, right? That it's about a particular group of people who we're very worried about. I mean, we hear about 15 and 16-year-olds who are leaving home and are flying overseas to get in something that they don't know. Of course, that is worrying. But we're being told that this act is the way to deal with that. If you look at another part of the introduction, you see it says, it also provides a judge with the power to order the seizure of terrorist propaganda, or if the propaganda is in electronic form, in order to order the deletion of the propaganda from computer systems. So what's this about? Well, once again, we've heard all about this recently, haven't we? About the radicalization from people who are using the computers to get these kids to leave the country and go overseas. That's what this act is really about. That's what they're leading us to believe. We've seen it in the paper. That's prominent in our mind. They're trying to tell us that that's what the legislation is aimed to deal with. Secondly, I think that they want to make it very clear that there's a housekeeping exercise going on here. That things don't work too efficiently in government. They never have, they never will, but it's always good to be able to make things work better. So in terms of the Immigration and Refugee Protection Amendments, we're told that the aim is to define obligations related to the provision of information in proceedings under the Immigration Act. What a fabulous thing to do, to define obligations. Why didn't we think of that before? That's a wonderful bill. You read this and you think this is going to be great. Well, what I'm going to suggest to you is that this bill is not about these things. It's about something that is not recent. It's about something that's been going on for a long time. That the aim of the government is not to deal with recent late 2014 events in Canada. That what the government is trying to do is respond to something, but what they're responding to is judicial decisions that have created major setbacks to their agenda. If you want to put it simply and bluntly, in Parliament we really don't have any opposition anymore that can stop the government. Outside of Parliament we have an opposition, and the leader of that opposition is Beverley McLaughlin, the Chief Justice of the Supreme Court of Canada, who the government goes out of their way to try and demean. What Beverley McLaughlin has said to this government is, if you want something as law, you have to bring it before our court, you have to actually give reasons for bringing it into law, you have to defend these reasons in this public forum, something that doesn't happen in Parliament anymore. And we will tell you, we will ask you questions, you will ask your lawyers questions about what you are trying to do. If you cannot defend it satisfactorily, we will hold that it's not legal. We have an arena, a forum of public debate, because it doesn't exist in Parliament. So, let me try and defend this view that what we have is a government pushing back on the judiciary by telling you the story of what the government is actually responding to in this act. And there's really 4 cases that I want to refer to, and I want to refer to them quite quickly. First of all, I refer to this idea that CSIS sources should remain anonymous. Well, in 2014, Mohammed Harkat challenged our security certificate regime. He took it to the Supreme Court of Canada, and he lost. But the government also lost in that case, and the government lost because they made a pitch to the Supreme Court. We need you to recognize absolute privilege and anonymity for our sources. And the court said that's not a good idea. And they offered reasons why it isn't a good idea, and I think you can think of some of them. And so what we have, a few months later, is the government saying to the court, well, we think you're wrong. We think this is a great idea. So there's number 1. It's a direct response to a judicial decision. Number 2, I want to go a little bit further back. Omar Khadr. In the Omar Khadr decision that went to the Supreme Court of Canada, the Prime Minister against Khadr, Khadr made this argument that even although he is locked away in Guantanamo, when CSIS officers come down to interrogate him, they have to abide by the Charter of Rights. And the Supreme Court of Canada agreed that the Charter has extraterritorial effect. So what do we see in this legislation, or in Bill C-44? What we see is the attempt to ensure that there is judicial warrants for CSIS whenever they go overseas. It's a direct response to the decision of our Supreme Court. This isn't something new. It's something that they've been thinking about and working on for a long time. I want to go even further back. I don't know if you remember this far back, some students probably won't, but you remember Hussein Abdul Razik, the Canadian citizen who went to visit his mother in the Sudan. He was arrested by the Sudanese, and he couldn't believe what was happening to him because they were asking him about questions. They were asking him questions about his connections in Canada and his behavior in Canada. He was, he claims, tortured by the Sudanese, and then CSIS arrived to get him. And CSIS said to him, according to Abdul Razik, that Sudan would be his Guantanamo. He would never see Canada again. He is a Canadian citizen. He was released by the Sudanese because they had no evidence against him. He was in fear of his life, so he went to the Canadian embassy. And at this stage, through American pressure, or we assume it's through American pressure, his name appeared on a no-fly list in the United Nations. And the Canadian government said, we cannot send you home, and refused to issue him a passport. He eventually managed to get over the passport hurdle, and then they said, we will grant you a passport if you get a plane ticket. And this man was indigent at this stage. He was begging at the embassy. They knew he wouldn't be able to get there. And the government also announced that because he is on a no-fly list, it would be a crime for anybody to give him money, to give a terrorist money, in order to get him back home. 115 Canadians donated money, including Warren Almond, I should say. Well, he was the Solicitor General? I think he was the Solicitor General. 115 people gave him money so he could get home. He took a case to, he had to take a case to the federal court. 107 pages, Justice Zinn told the Canadian government they were abusing process. There is now a $3 million lawsuit by Abdul Razik, who's now back in Canada, against Lawrence Cannon, the Minister of Foreign Affairs at the time, and a $24 million suit against the government. There was no evidence that was used. He was being prevented from coming back to the country. What is the no-fly list about? The no-fly list is not about teenagers leaving Canada to get to Syria. The no-fly list is to prevent Canadian citizens from coming back to Canada. Why do we not want them to come back to Canada? Because under the other aspect of Bill C-44, we want to take away their citizenship when they're outside the country, and we want to do it when they don't have access to legal advice and to the full amount of procedural protection they would have in Canada. And how do we know that that's what they're thinking about? Because the British are already doing that. They are already stripping people from their citizenship when they are overseas, so they cannot actually come back to the country. That's what the no-fly list is about. If you see this as being a response to what the courts have decided. My fourth example relates to, again, quite an early case. Hassan al-Amri actually was one of the individuals who originally challenged with Adil Sharkawi our security certificate regime. And Almray won. Sharkawi and Almray won in the Supreme Court of Canada. The government was told, rechange the process. What we are doing is we're removing people from the country. We are doing so on the basis of secret information. And basically, Chief Justice McLaughlin said to the government, the same rules that applied to King John in the 13th century apply to you today. You are not immune from the same rules that the common law apply. You have to give people a hearing before you detain them and before you actually throw them out of the country to possible torture. So the argument from the court was, at this stage, you have to change things. The government did change things. Almray had his security certificate quashed again by the courts. And At that stage, he began to apply for permanent residence, or he continued applying for permanent residence. And last year, the federal court turned to the government and just said, stop hounding this man. We are not going to allow you anymore to hold him inadmissible. You've been doing it for 12 years and you have nothing. Now, here's the key. It's the security certificate rules that Bill C-51 is trying to change. And they are trying to change it in a way that looks absolutely benign. You remember my reference to defining the obligations. Let me identify to you the key provision that I think explains what the government is trying to do here. Section 77 of the current Immigration Act says this. Very, very simple. The minister shall file with the court the information and other evidence on which the certificate is based. You read that, you think, okay, the minister is required to, if they're trying to remove somebody through a certificate, they have to prove that the certificate is reasonable. They have to produce the evidence of which it's based. Very, very straightforward. The new act says, the minister shall file with the court the information and other evidence that is relevant to the ground of inadmissibility stated in the certificate. Say what, indeed? It's like the first one says that they have to provide the evidence on which the certificate is based. The second one says they have to provide evidence that is relevant to the ground of inadmissibility. It looks like it's saying the same thing. It's not. The first present system is a system that says you have to produce evidence, but you also have to produce evidence about the credibility of the source and how you got that evidence. What the government is saying is we're going to introduce the evidence on which it's based, and here's the kicker. But we don't want to actually have to tell you that we gained this evidence through torture. That's what the Act is about. Paranoid, you think. The man's an idiot. He's paranoid. Let me go to CBC website, 2012. Headline, CSIS may use intelligence derived from torture, Taves says. Public Safety Minister Vic Taves, now a judge. Public Safety Minister Vic Taves quietly told CSIS, the government now expects the spy service to make the protection of life and property its overriding priority, and may, under exceptional circumstances, share information based on intelligence that may have been derived from the use of torture. We have a sinister bill here. We have a bill that aims to make decisions based upon evidence that could have been taken by torture. We have a bill that can be used, as it has been used in Britain, to strip people of their citizenship and make sure that they can't get here. We have a bill that tries to counteract the application of the Charter overseas by getting prior judicial warrant. And we have a bill that does a whole lot of other things that Elizabeth will tell you about. This is a nasty piece of work.
I'm going to pause for just long enough. I see a lot of people standing at the back and some sitting on stairs. Anyone who's got an empty seat next to me, put your hand up. There are some empty seats down here. And while you're finding your seat, I just want to tell everyone in this room something that you may not know. That analysis of C-51 and C-44 that Donald Gallaway just gave us, in particular Part 5 of C-51, and the change that's been made that will allow the introduction of security certificate evidence without disclosing that it was obtained by torture. This is a legal analysis that no one else in Canada has yet heard. Donald Gallaway has submitted it to some papers as an opinion piece. I hope published, I'll be raising it in Parliament. Most of us who have been studying C-51 from the day that it was tabled have been focusing on the earlier parts of the bill.